got 5 pages of things. Hello, Belinda. How are you?
Hi, Katie. I'm good. How are you?
I'm very good, thank you. So sorry to anyone who's been waiting for us to join. We had a little technical error, but we're all good now. So thank you so much for joining us today. There'll be quite a few people hopefully watching us live. And for those of you who are watching us on replay later, because we do get a lot of people watching on replay, then welcome and thanks for joining us. So I'm really thrilled to be joined today by Belinda Lester. Belinda Lester is our resident employment law expert at Flexible Working People. And she advises businesses and individuals on all aspects of employment law and is particularly passionate about helping women in the workplace. She shares her expertise and insights generally around employment law rights. But today we're specifically talking about is this the end of remote working? I think that it's been almost 4 years, hasn't it, since the pandemic and since the whole world was sent home to work on furlough, and we're kind of still talking about it. But there's been such an enormous shift in the way that we work, and it's had such a long-term impact on the way we work generally. For most employers, there's been a retention of some sort in the way of hybrid working, but not all employers are fully supportive of this move to remote working. And a number of employers are no longer keen to have their people working from anywhere and are citing the comeback to the office as better team building, better management, there's lack of trust, increased cohesion. So there's all sorts of reasons why companies are wanting their employees back in the office. But changing these patterns is actually having a massive impact on employees. And in some cases, some people are really struggling to work at all. And this is particularly impacting women who are being forced out of the workplace altogether, as employers are rescinding on all the flexibility that they once offered. So these are the sort of all the topics that we're going to be unpacking here today with Belinda. And there's been a recent case that Belinda is going to talk about, which covers many of these issues. So actually, it's quite timely that this live has come today, because this case, doesn't it? It covers quite a lot of the issues we've just talked about. So welcome, Belinda.
Thank you. Thank you. Good to see you again. The case that we're talking about is Wilson and the Financial Conduct Authority. And it's an extremely interesting case. And I think I'd like to sort of talk a little bit about it. I'll probably talk for a little while, but it touches on so many important issues that I think it's worth summarising it, because I think it really does address the sorts of the advice that I'm going to be giving, really in answer to some of your other questions about what women should be doing and how best to frame their flexible working, and how best to push back against their employers if they feel they need to for reasons related to the sorts of reasons that tend to relate primarily to women, which is flexibility due to childcare and other caring responsibilities. So if it's okay with you, I'll just summarise very briefly the case of Wilson.
Absolutely.
Wilson was somebody on £140,000 a year. She was a senior manager. She wasn't on the leadership team, but she was certainly somebody in a management role. During COVID, everybody worked remotely at the FCA. I think the important thing to note about this is that this judgment has just come out, but clearly that's because the case was issued, the claim was issued quite some time ago.
Yeah.
Probably shortly after people were starting to come back to work. She worked remotely, permanently at home during the pandemic, as did everybody at that time during lockdown.
Yeah.
The FCA subsequently brought in a hybrid working policy whereby some staff had to be in the office 40% of the time and could work from home 60% of the time. And with managers, they had to be in the office 50% of the time and could work from home 50% of the time. So they didn't bring everybody back permanently to the office, but they, like many businesses, recognized that most of their staff did not want to be coming permanently back into the workplace. And presumably, following consultation, they implemented this hybrid policy, which, as I say, is what an awful lot of businesses are doing.
Yeah.
Mrs. Wilson felt very strongly that she shouldn't have to come back at all into the office, that she'd been an extremely high performer. There'd never been any concerns about her performance whatsoever. She'd scored highly on her appraisals, and that there'd never been any issues raised whatsoever about whether, her working remotely was having a detrimental impact.
Sure.
She made a flexible working request and it was turned down. She appealed and she was unsuccessful on appeal. And so she brought a claim in the Employment Tribunal for a breach of Section 80F of the Employment Rights Act, which is the right to request flexible working. Now, it's a the judgment isn't actually that long, and it's available online on gov.uk, and I would actually recommend people to read it, because it's very simple, it's not that long, and it sets out very clearly the rationale that the tribunal came up with, because Mrs. Wilson was unsuccessful in her argument that the employer had not complied with its obligations. And just to summarise, I'm sorry if this sounds like a bit of a lecture, but I think it's really important, because this case is going to feed into so much of what we can talk about. An employee has the right to make flexible work request. They don't have a right to work flexibly. And the employer's obligation is that they have to respond to that request within a time frame, within a time limit, and they can only turn it down if they can show either that there'll be a detrimental impact on quality or a detrimental impact on performance. Those are the two grounds on which an employer can refuse, and they have to go through the list of things under the guidance that they can turn down on. And she argued, I've proven that there's no impact on my quality, and I've proven that there was no impact on my performance. And you would have thought that she would have a slam dunk claim. Yeah. But what the tribunal said was that during the pandemic, she did show that she was able to absolutely work really well and really efficiently in those circumstances. But those were not normal working. That was not normal working. That was not business as usual for the FCA. Nobody was in the office. There was no face-to-face. Everybody was at lockdown. And in those circumstances, she did a brilliant job. But they're saying that it was the FCA had the right to look at what business as usual looks like, and not that she would be underperforming, but that she could perform better if she had some face-to-face contact during the week, if people felt they could approach her. There were a whole list of things that they went through as to why, not that she was underperforming, but why allowing her to work permanently from home meant that she wouldn't actually be able to perform to the actual level that they now wanted her to perform under this business as usual.
So it didn't go her way.
It didn't go her way, and the tribunal said that what was really important here was that they were very praiseworthy of the person who had made the decision, who'd conducted the who'd made the decision on the application and turned it down. And they said that she was an incredibly good witness, because she had shown that she had given proper thought and consideration to it. She hadn't just dismissed it out of hand. And she had come up with very cogent and legitimate reasons why she wasn't criticizing Mrs. Wilson's performance, but why not being in the office at all would impact. And it was really clear that there was a lot of praise given for the fact that it wasn't just that the employer was saying, well, this is our policy, like it or lump it, but they were very, very good at demonstrating that they had put their minds really properly to the questions that, to the issues, and had addressed those properly and were not making up. The other thing that was really important about this is that Mrs. Wilson only made this claim on the basis of Section 80F of the Employment Rights Act. She didn't argue that she was disabled, that she had any health reasons, or so that there needed to be reasonable adjustments. And she didn't argue, in fact, she didn't give any reason for why she was making her flexible working request. So she didn't say it's because I have childcare, or it was simply, I've been doing this for X amount of time. I've been doing it really well. why can't I continue doing it? So what I would say is, as an opener for everybody, and I've always said this to people always say, should I tell my employer why I want to make this flexible working request? And, I don't want them to think it's because I'm not, committed, or you should definitely, if the reason that you want to make it, if you're a woman, if the reason you want to make a flexible working request is because the travel to and from work, for example, would mean that you couldn't get to nursery to pick up your child, or whatever it is, give that as a reason. Because if you're just bringing the argument under Section 80F, there's
What's it? Section 18F, did you say?
80F of the Employment Rights Act. If you're just making the application under that, and you're not also talking about possibly indirect sex discrimination, the tribunal, the employer doesn't have to necessarily think about that, unless you're actually saying, well, I understand your reasons, and yes, those reasons are legitimate, but are they proportionate? Are they a proportionate means of achieving your aim, given that I can't comply because I'm a woman with childcare?
So there's so many interesting layers to this, which was obviously why you wanted to talk about this. So let's start and sort of unpick it a bit. So I think the first thing that's come out of this is that she based it predominantly on the fact that she'd worked successfully from home during the pandemic, and therefore why. And that is an argument that most people say. It's like, well, I was super productive, everything was fine. So this is a really interesting case.
It is.
In stating that actually conditions were different then, and now people are back in the office. There are different reasons why it would be beneficial for you to come back in. So that is going to have a really big impact, this case. Yes. I can see that's going to have a really big impact on, what that looks like moving forward in terms of setting a precedent now for people who are using that argument. So it's really interesting to hear you talking about the other reasons to stay. So I think the first thing I would ask is then, that does that mean that, the question, does this mean that they can legitimately turn down flexible working requests now forevermore on that argument? So do you think that that's going to set the scene for the future?
Absolutely not, because the tribunal judge said every case is going to turn on its own facts.
Yeah.
But I think if I'm advising employers, because I do advise both, so if I'm advising employers, I'd be saying, make very, very, you need to be very, very careful. You can't just have a blanket, well, we don't want to set a precedent, or we just think it's going to be better because it just is obvious, because it's not. Every case is different, and it may well be that in certain and it may be that it's much more important for management than it is for junior, or it may be that it's more important for junior than it is for managers. But the idea is that as an employer, it's very, very important for you when you're drawing up your policies, whether they're flexible working policies, hybrid policies, working from that they actually are careful and assess what are our business objectives, and what is the best way that we can achieve those objectives. And then if they really want to think about diversity and impact on women and impact on people with disabilities, once they've done that, they should then go through it all again and say, will these requirements have a detrimental impact on a certain group of people in our workplace? And if so, are they nevertheless proportionate? Because that's going to have a benefit to them in terms of being able to just explain to staff, because an awful lot of problems happen when there's a breakdown in communication.
Yeah.
And when employees just feel that they're not being heard, they're not being listened to, that their needs are not being addressed. As an employer, nobody's saying you have to do this. Nobody's saying you have to allow everybody to work from home, or you have to allow people to work from home X number of days. What they're saying is, think about it.
Yeah.
Think about it.
And I think that what you've made really clear in this is that in this case, the FCA put a very strong case, and they didn't just carte blanche go back and say, no, you can't. They were very specific, which is why, and that's something that I think many employers, obviously they need to get advice, but I think many just go back without doing that due diligence necessarily to the level that they need to. and they're just being refused their requests because they just don't want everyone to maintain that working from home, remote working. And so this is really interesting, just to break it down into actually, getting into the policies, the objectives for the business, what does it mean, really thinking through, and then the impact on others, particularly in light of their, D&I, diversity and inclusion. And he was saying that you want to be a company that, brings women and supports people who need to work in flexible ways. So you really need to be considerate of all of that.
Yes, and that doesn't mean to say, as I said, it's about really thinking about it, and it's about having a very clear, evidence trail, and not just ticking boxes.
Yeah. So conversely, on the employee side, you've touched on that, because there's obviously always two sides to this. So one is obviously that the employer has to really think about this, but back to Mrs. Wilson, did she put a strong enough case forward, and are there ways, because you were talking earlier about, she only relied on section 80F, is that right? And actually we talk a lot in the group, and when we talk to individuals and employees about whether or not they should put the reasons for their flexible working requests when they request it. And it's really interesting to hear you say, yes, they should, because generally people advise them not to. Don't say that, because it will put you at a disadvantage. But I just want you to talk a little bit about that, because actually you've always said, yes, tell them.
I always think people should say. And I actually think that that men should too, because men sometimes get turned down. Direct discrimination, not indirect, because men can't bring an indirect sex discrimination claim on this, because it's not more men than women who have primary childcare responsibilities. It's more women than men who do. But some men do have primary childcare responsibilities, but they get turned down because employers just assume that a woman will do it. And so they turn down a man's request thinking, well, you don't need to do it, you've got a wife at home, right? And that's a direct sex discrimination claim if they allow women to work flexibly but not men. Yes. So I think, it's and also if you're wanting to do it for a health reason, whatever that reason is, personally, my view is let your employer know, because then you have more you have more protection apart from anything else. You've got the Equality Act, so that even if they can succeed under Section 80F of the Employment Rights Act, they've still got to show that it's proportionate means of achieving legitimate aim under the Equality Act. And they have to make reasonable adjustments under the Equality Act if it's a disability. So in my view, there is absolutely no harm and only any benefit in giving a reason. Now, obviously, if your reason is Mrs. Wilson's reason is, which, she never said it was because of her child, it might well not have been. She probably didn't plead that because that wasn't the reason. She just thought, well, hang on a minute, why should I go back to the office? I can do my job. And that might be the case. If there isn't another reason, then obviously you can't plead another reason. But if there is, I would say definitely state it.
Okay, so that's really interesting. So I would then broaden this, because we just talked about the impact of the pandemic, and this case specifically was about someone who worked from home when everyone was working from home and conditions weren't the same. But what does this mean, that employers can legitimately turn down flexible working requests even when employees have been working flexibly, successfully for years outside of, taking the pandemic out of this? So maybe they wouldn't rely on this case, but it'd just be interesting, because there are people who have worked successfully for years flexibly, and then maybe they get a new boss or things change and they decide they want to bring them back in. What does that look like?
Well, it really depends on whether their flexible arrangement has become a contractual right or not. A lot of during the pandemic, it was stated to be very clear that the temporary working from home arrangements were an emergency temporary measure, and that they were not bringing about a permanent change to anybody's contract of employment. Contract of employment is the document, is the agreement upon which this issue is going to be determined. The question I suppose you're asking is, if it was never sort of stated it's temporary, and they've been doing it not just during the pandemic, but we're now quite a long way out of the pandemic and back to normal for a very long time. would an employer simply be able to say, actually, do you know what, we don't want you working from home? In my experience, and I don't know, you may have a different experience, I haven't come across anybody who is still working like they were under COVID, unless the employer has just gone remote as a whole.
Yeah.
In my experience, what happened after COVID is that a lot of employers sat down and thought, well, nobody's going to be coming back. We're going to get massive pushback from our staff if we insist everybody's full-time back in the office. And also economically, they're going to be thinking, why are we paying rents for this big building when we can have a smaller building and have people hot desking, you know? So there was all sorts of reasons why I think an awful lot of businesses have gone to hybrid. And they will have done that by, they should have done that by consulting with staff and saying, we're thinking of bringing in a hybrid working policy, so people won't have to come back permanently. And that would then be, and then they would say whether it's their policy or a contractual variation. So I think it really depends on the employer and it depends on the individual situation. If there is a case where somebody has a contract of employment that says your usual place of work is our office in such and such, but actually for the past 4 years, they've never worked in the office, they could argue that there has been a variation to their contract by custom and practice and that their place of work is now at home. Does that mean that the employer can't bring them back to the office? Arguably, it would be a place of work redundancy situation.
That's really interesting, Belinda, because someone's actually just commented there are lots of employers who are asking people now to come back full time. Right. And so if their place of work had sort of changed, and in some cases, some offices gave up, or some companies gave up their offices altogether and decided to go fully remote. And now as things are changing, they're wanting people back and getting offices. So there's lots of switching up.
Yes.
And that's really interesting.
It's really interesting because if they went fully remote and they got rid of their offices and people were able to work from anywhere in the country, some people will have relocated.
Yes.
And some people's contracts, even if they haven't changed it on paper, have, as a matter of fact, varied their place of work to be wherever they are. If the employer is saying we now no longer need people to work remotely, we need people to work in this particular location, arguably that is place of work redundancy situation. We are offering you some alternative employment. For some people, it will be suitable. For some people, it will be suitable alternative employment for them to come back to an office. But for others, particularly those who've relocated, it's no longer suitable. So they might find that their role is redundant.
By means of
place of work redundancy.
So thank you, Alison. Alison, who's watching, has said she's up and asking the questions. I don't know if you can see them, but some people might have relocated internationally as well, because they went remote. And so there is a case.
Well, international relocation has its own issues. I mean, if they were allowed to do that, because there's all sorts of tax implications, there's all sorts of implications by people working permanently in another location. It was never a simple question of people upping sticks and going abroad. People might have done it, but it's a bit high risk for the employers. But yes, I think, one would hope that these situations are, I think the first point of call is, what does your contract of employment say? Was the contract varied either actually or by custom and practice? Are you being consulted about a place of work change? Is it going to be a permanent end to remote, or is it going to be we just want people in? The normal place of work is still going to be remote, but we're going to want people to travel a bit more. That's a contract variation rather than a redundancy. Yeah. So you want to consult and get people's agreement to it. But if it's a permanent, your actual main place of work is no longer going to be remote, it's going to be in our office, that to me is a redundancy situation.
Okay, so that's really interesting. Okay, so we've talked a lot so far. We're running out of time, but I want to run on because we started a little bit late and people watching this will be watching this later. But let's just talk about the steps that employers must go through in order to bring people back into the office if they have been working from home. So it'd be good for you to give some thoughts around that.
Yes. So as I say, the very first thing is the contract. And as I say, if people are still working from home in exactly the way as they were during COVID, I would say that arguably their contracts of employment have been varied by custom and practice.
Yeah.
That's not legal advice. That's a general rule. Obviously, it'd be case by case basis. In which case, if an employer then wants to vary, as we said, is it a variation of contract term? Could that possibly trigger a redundancy? If they've implemented a hybrid working policy, whereas the normal place of work is the main office, but we have a hybrid policy which we can amend from time to time, as all our policies on our handbook, and we've assessed that the hybrid working policy as it was isn't really working, then again, you would need to consult with staff to do it meaningfully, but you can implement policy changes following meaningful consultation with a view to getting people on board. It's not a breach of a contract term, but if you do it without consultation and without engagement of staff, arguably it's a breach of trust and confidence, and some employees may claim that they've been constructively dismissed if they're forced to do something that they haven't been meaningfully consulted about. So that's the one thing to think about there.
Yeah, so I was going to ask you what rights employees have on the converse side. So do they have any bargaining power in this?
Well, they should be putting forward all their arguments as to why the new policy change is going to be detrimental on them, and make sure that their employers are listening and make sure that all of these points are taken on board. I think the thing that a lot of people are concerned about is not so much that new policies are coming in, but there's been a lot of stuff in the press about companies enforcing their policies by naming and shaming staff that
are talk to you about that next.
Not adhering to these policies.
Yeah.
And there's been a lot of headlines and headline grabbing and trying to clickbait about disgusting employers and how outrageous. But actually, if you look at it objectively, what these employers are doing by naming and shaming or penalising staff is simply saying this was our policy. It was a hybrid policy that we brought in after the pandemic to try and give flexibility to staff. We've brought this policy in following consultation with staff, and you managers who were supposed to be the ones enforcing this policy amongst the junior staff are not complying with it. And an employer does have a right.
Agreed. But some of these firms seemingly are taking it a bit too far. So we're seeing attendance being checked on badge swipes, people being graded on their office attendance. But more than that, it impacting their performance reviews. Now, is that legitimately, is that something that's...
Well, yes, again, I say, look, as you know, I'm very, very pro employee, I'm very much on the side of flexibility and accommodating, employees as much as possible, particularly when policies have a detrimental impact on specific groups of people. So I'm speaking from as somebody who is, very claimant friendly, but I do think that a lot of these headlines are not looking at the actual reality, which is that these policies were brought in, as I say, like the Wilson case and FCA. We need bodies in the office. We need managers there to mentor the junior staff. We need people to be able to have face time. Because you're a manager, you don't report necessarily day in, day out to everybody. So you're being a bit fast and loose with our policy, and thinking that you can do what you like, and actually you can't. And I do think that that's legitimate. I do think employers do have a right, if they have brought in a policy with everybody on board, and that policy, or not everybody, but having, explained their rationale for a need for hybrid working, and that policy is applied to everybody, I don't think that there's anything wrong with an employer enforcing it in the way that
I would agree.
Any rules in the workplace.
So I would agree to a point that yes, you brought in certain parameters by which people should work and it should be enforced. I think that when it falls into things like impacting your bonus, performance related, then that starts to feel a little bit uncomfortable for me.
I think for people who can't comply with the policy, the answer to that is not to not comply, it's to make a flexible working request.
Right.
No, I mean, I do, because I have to look at this from both perspectives. I get it that for some employees, adhering to this strict policy possibly doesn't work for them. But the answer then is not to just disregard it and do what they like. It's to put forward a flexible
working request
and explain, I understand why you've got this policy as a general policy, but the impact of the policy on me is X because of Y. And I would like to make a flexible working request.
Yeah. And then back to the advantages and disadvantages, or why give, when you make your flexible working request, what are the advantages and disadvantages of giving reasons for it?
Exactly. So I do, whilst I completely sympathise with people who feel, this doesn't apply to me because I'm great at my job, I've done really well in my performance review, like Mrs. Wilson, right?
Yeah.
I've done really well. Why am I suddenly being downgraded because I'm not adhering to this policy, which doesn't really impact me? The employer may be able to say, well, if you don't think it impacts you and you don't think that this applies to you because of your circumstances, the correct procedure is to make a flexible working request.
Yeah, totally agree. Okay, that's really good. Okay, so this case is presumably what you would call a landmark case.
I'd say it's a landmark case. It's not a precedent because, as I say, the judge was very clear that it's this is very
based on case-to-case basis,
case-by-case basis. But I think it's an extremely useful case for everybody to read. It's, as I say, it's not long. It's not complicated judgment. The area of law is not complex, and I think it's a brilliant starting point for people, employers and employees, actually.
You spend a lot of time still advising employers on this in your practice.
Yeah, I do speak to employers who are very much of the view that, we have been really flexible. We've brought in hybrid policies. We recognise that people want to work part of the time from home. And, but we want to be able to enforce those policies. And I get it. If you have a policy and people are just ignoring it, as an employer, you do have a right to try and enforce the policy. If all the staff feel that the policy is unreasonable, then it is for those staff to raise that issue.
And I feel like people put forward flexible working requests that get refused, and they appeal and they get refused. And unfortunately, many of these individuals don't have the means to get legal representation. So lots of these end up, they just have to comply with the denial of the request and just go back to work or leave their job. Like, it's
terrible. It's terrible, which is why I feel very strongly about, educating and giving out information to say to people, you might not be able to, get a solicitor to help you with this. But when you're making your flexible working request, don't just look at the regulations around flexible working. Look at the Equality Act. What are the reasons you're making this request? Because that's going to be the point where HR will often fall over. A lot of HR people don't think about that. They're just looking at the Section 80G. They're not really thinking about whether they've got to make reasonable adjustments or whether there's a provision, criterion or practice which is having an adverse effect on a certain group of people. So if the reason you want to work flexibly is because of either a disability or because you have caring responsibilities or other responsibilities which mean that you and your protected group, if it's indirect discrimination, or because you as a man want to do it and that the employer allows it for women, and if they turn you down, then of course you've got a direct sex discrimination claim. So that's my bit of free info. If you can't get a lawyer,
so powerful, Belinda. You think like this, just that bit is so powerful in itself. Actually, I'm going to make sure that message goes out really widely, because I don't think that people think about that aspect.
No, they don't. It's so important. If it's true, I'm not saying to people to make stuff up at all, but if it's true, it can only help you rather than hinder you
It's okay. As always, I love doing these with you. It always uncovers some excitement. I think, oh, okay. So is this the end of remote working as we know it, Belinda? Is this the end of working from home, this case? No.
No, I don't think so.
I would answer that, but no, nor do I.
No.
Okay. So any last thoughts, advice? Not advice, because you don't give advice, but guidance.
I think really my takeaway from this is, if you're an employer and you have policies that you want to implement and enforce, make sure you've got really good reasons for it, and that you can back that up with the evidence, and that if you can demonstrate that you've given consideration to the impact that those policies might have on certain groups of people. And if you can do all of that and show that this is something that you need and it's proportionate, feel free, go ahead and do it, because I think the tribunal has shown that in those cases, you've got a really good chance of being able to, stick with what it is you feel you need as a business. Businesses are allowed to run as businesses. If you're an employee and you want to make a flexible working request and you're worried about whether you should be giving the reasons why, definitely do.
Yeah.
And if you think that those reasons would fall within a category in the Equality Act, so a disability reason, or because you have a protected characteristic, maybe sex discrimination, indirect or direct, make sure you refer to the relevant section in the Act. If you're not a lawyer, you can look up the Act. You can find the
Act?
The Equality Act 2010.
Oh, sorry, not the Act. Look up the Act, but then work out the Act.
It's always better if you can get legal advice, but not everybody can. Try and make your case on all aspects so that your employer has to put their mind to it. It doesn't mean they're going to agree, but it's going to give you a lot better chance.
And go away and read the Wilson versus the FCA as well.
Wilson and the FCA is a great case.
All right, brilliant. All right, well, look, we've run over, but I think that was a really good session, as always. Always gives great food for thought. I loved it. I'm hoping that there was lots of value here for both. I think there was for both, because we like to cover both the employee and the employer perspective in these lives that we do together. If you've got any questions or comments, please do leave them in the comments box. Belinda is in our Flexible Working People Facebook group. So I said she's our resident employment specialist. So she is there and accessible. And
Lionshead Law, so
Lionshead Law, yeah.
There's not just me there is a team of employment lawyers, and obviously I'm always here to answer questions, but we do have a team of employment experts. We are very hot on all of this. This is our, it's our favorite topic.
Yeah.
These sorts of issues, because these are the ones that come up time and time again. Discrimination claims.
Absolutely.
They are something we're passionate about at Lionshead Law.
So do please reach out to Belinda via her LinkedIn, Lionshead Law, if you want to follow up. All right. Well, thank you so much, Belinda. As always, it's been a pleasure, and have a great day. And thank you, anyone who's listening. I hope you got some good value from that. Take care.
Bye-bye.
Bye.